let's go ahead and go on the record on BA 487932, People versus Masterson. Counsel, can I have your appearances for the record, please?
Good morning, Your Honor. Thomas Mesereau, privately retained, representing Danny Masterson, who was not present. We're appearing under 977.
And also Sharon Applebaum, Your Honor, also for Mr. Masterson.
Good morning, Your Honor. Reinhold Mueller for the people.
All right, and I did note there's actually a signed waiver under 977B, so I allow the defendant to absent himself and you appear in his place. All right. Did I hear right? Was there an objection? Well,
Yes, Your Honor.
all right, go
Do you
ahead.
prefer us to stand, Your Honor?
No, please don't. Seriously, that's fine. Just sit.
We are objecting to the media requests, Your Honor, that have been, I understand there are many in the file at this time. We would object on the grounds that it creates unfair prejudice for the defendant. This is a case that is being followed by the media closely. There it's being broadcast all over the country. There is misinformation out there as well, Your Honor, as I'm sure you're aware. Different blogs have different information, and so as a result, we would prefer the media to be kept out of the courtroom so that there is a fair trial should and if this gets that far.
All right, people, any position?
People have no objection to the media submit.
All right, when you say I'm sure you're aware, I'm not.
Oh.
I don't keep track of any of that stuff, so I'm not aware of any misinformation or whatnot. And I guess the best way to get accurate information is if you have it firsthand. So there have been many times the media have been present, and I don't think it's unduly prejudicial for the defendant to have members of the media present, and they have a right to be. So your objection is duly noted, and I understand what your concerns are, but it is overruled. All right. So before me at this point, I have the demur that has been filed by the defense, and that was filed September 18th. Then I have the people's opposition, I think that was filed October the 1st. Then I have the reply to the opposition filed October the 7th. And I have the reply to the defendant's reply to the people's opposition, filed October the 15th. The court has read and considered all of the moving papers, and I'll let the defense go first, and if you want to add anything additional to what you have argued already in your moving papers.
Yes, Your Honor. Specifically going into the reply and the objections of the people in their opposition papers, they seem to be stating, at least in the reply, that the one-strike law is considered an alternate sentencing scheme. We do not disagree with that. That seems to be the crux of their argument. In Acosta, as we mentioned in our moving papers, the Supreme Court of California decided that both the three strikes law and the one-strike law were considered alternate sentencing schemes and not enhancements. So as a result, when we discuss Turner in our papers, which said that the three strikes law does not govern the statute of limitations, which is the central issue here, we find that there is a discrepancy when the Perez case states that the one-strike law does apply to the statute of limitations. In Turner, as we've noted multiple times, it focuses on the offense itself, the underlying offense, rather than the offender or any other sort of prior convictions at that time. The issue with the one-strike law that we have is that under the particular circumstance of the multiple victim circumstance, there is nothing additional, no additional element, no aggravating factor in that particular circumstance that necessitates activating the one-strike law, which carries a sentence of 15 years to life. That is what the prosecution is hanging their hat on to say that the statute of limitations does not exist. So in all of the other circumstances for the one-strike law, for rapes that include kidnapping or burglary or tying someone up or administering a drug, there's an aggravating factor that the people have to prove at trial. In this case, they don't have to prove anything extra. They just present their case on the three different counts, and if found guilty of all three counts, or even two of those counts, they get to impose the one-strike law. However, this creates an analogous result if only one count they are found guilty of, the defendant is found guilty of, because then this multiple victim circumstance no longer applies, which means the statute of limitations in this theory would no longer apply, and the entire case would be dismissed. So for these reasons, Your Honor, and for the fact that these cases are so old that they have outrun the statute of limitations, which was, whether you find it to be 6 or 10 years, would have expired at the latest at the end of 2013. Under 261A2, this case is no longer able to go forward, and this court just does not have jurisdiction. So we would ask for this court to sustain our demur and to dismiss the case.
People?
Your Honor, first of all, one needs to look at the statutory language under Penal Code Section 799, which dictates whether a felony offense can be commenced at any time. And that is, in part, if an offense is punishable by life imprisonment. Now, the language under 799 refers to an offense punishable by life imprisonment. So now, the argument becomes, under Turner versus under Perez, is there a distinction between whether the offense itself is a life sentence punishable by life, or is it whether there are some other circumstances that would dictate that? For instance, in Turner, they were talking about the 3 strikes law. They were very specific. They narrowed it down. It really had to do with the fact that there were prior convictions, that the defendant had prior convictions, which enhanced the substantive term on that particular offense. Perez distinguished Turner by specifically stating, and by the way, the facts under Perez were factually very similar, with the exception of the fact that there was, in Perez, there were multiple 288B offenses, versus here we have multiple 261A2 offenses. But otherwise, it was beyond, the offense itself was beyond the statute of limitations, but for the fact that there were multiple victims. So Perez looked at it very carefully, and it made a very, very narrow distinction, saying that, and it was a very important distinction, that the difference between an enhancement under prior convictions versus a separate sentence scheme, or a separate sentence under a one-strike law, in particular to the multiple victim enhancement, is distinguishing. And what they looked at is language saying that in the present case or cases, under Penal Code Section 667.61, under the multiple victim enhancement, it talks about multiple victims, conviction of a multiple victim in the present case or cases. So we're not talking about some prior convictions. We're talking literally about the offenses in the present case or cases. So if you've got more than one charge in the present case that falls under the 667.61 sub C section, then the 15 to life then kicks in for that particular offense. And it's also clear, if you look to the statutory language and the legislative intent, if you look under the California bill analysis that was argued and discussed on the Senate floor back in 1993 and 94, they specifically talk about how the one strike is different in that this is to impose a life sentence on the particular offense itself, rather than a life enhancement that you would see under some other, like for prior strike convictions. So the California legislature, when they discussed this, they were very clear about wanting to make a separate crime, in essence, punishable by life sentence. In fact, there was a discussion at that time between the Senate Bill 26X and an Assembly Bill 1029. And the Assembly Bill had passed, which, quote, had the same intent as the Senate Bill 26X, but established, quote, a life sentence rather than a life enhancement. So they were very clear on what they wanted. and the statutory language and the legislative intent is very clear. Furthermore, as defense counsel is saying that there's nothing additional, or that we do not have to, people do not have to prove anything additional other than that there were additional victims. So in other words, other aggravating factors under the 667.61 would be if there was tying or binding, or victims were drugged, or there was a firearm use. We would have to prove that in fact there was a firearm use, or that there was tying and binding. Well, we do have to prove something here. We have to prove that there were additional victims that were raped. That's our burden of proof. So to say that we have nothing additional to prove is just, it's a little disingenuous. Also, as to the statute of limitations, that it doesn't apply if for some reason we don't prove that there were multiple victims. Well, that goes for anything. If we have an enhancement for a firearms enhancement, or a tying and binding allegation, if in the course of the trial we don't prove that there was a firearm or that there was tying and binding, then the same result occurs. So that again is not, I don't think that carries any weight. So based on that, the people's opposition papers that are filed, our surreply, we would ask that the court dismiss this tomorrow.
Your Honor, again, just to say, Mr. Mueller's argument centers on the fact of an enhancement versus an alternate sentencing theory. He doesn't explain how you can reconcile Turner, which, looking at an alternate sentencing theory of the three strikes law, said that that did not govern the statute of limitations, and also looking at Perez, where they say the one strike law may govern the statute of limitations, how those can be reconciled. The California Supreme Court has not made a decision on this. Both those cases are on persuasive authority on this court. Neither are binding. And as a result, this could create all sorts of issues for defendants that can be tried with cases that where someone comes forward and then the prosecution is allowed to just sit back and wait any sort of number of years for multiple victims to come forward, multiple alleged complainants to come forward, and wait to file these cases 20 years down the road. For these reasons, Your Honor, we submit.
Anything further?
No, Your Honor.
All right. Like I said, the court has read and considered the moving papers. I've also read over Turner and Perez and a couple other things. In this case, the vehicle in which you are making the motion is the demur, and so Penal Code Section 1004 sets forth the 5 factors, and you're relying on factor number 1, the court has no jurisdiction. And I'm saying that because also in your moving papers, you throw out a due process kind of claim. So I'll get to that in a second. So just looking at the jurisdictional, because I believe that's the only vehicle you could use in order for the demur. And the demur is a very simple type of process. You look at the 4 corners of the document and look at whether or not it's sufficient in the accusatory plea. It's as basic as that. Your argument from the defense is that it's beyond the statute of limitations. Penal Code Section 800 et al. Sets forth what the statute of limitations, and that's for the underlying crime of Penal Code Section 261A2. The claim is that you look just at the crime itself and you go forward from there. And in this situation, it's not just the crime itself. The people have also filed a PC 667.61B and E4. And that applies that if there is more in that particular case, in that particular filing, on 4 corners of that document, there is more than one victim that is alleged. If that is true, then that would fall under Penal Code Section 799, subsection A, and therefore it is there's no statute of limitations, so people can file it under certain guidelines, certainly, but there's no 5-year, 6-year, 10-year statute. So looking at the 4 corners, the charges are there, plus the charge of the allegation of 667.61B, E, and 4. Now, you're right, both sides have pointed out there are two cases. The Turner case, first of all, happened in 2005. That dealt with a robbery, dealt with the three strikes law, and both of you have accurately kind of set forth what that is. And in that court, they said the statute of limitations excludes the time for enhancements. And you're looking at, it's for the three strikes law is for an offense, and not for the offense, but applies to the offender. So here you have a recidivist type of individual that has committed multiple cases that constitute strikes, and our legislature has decided that if you do this, then you're subject to this three strikes law. Now, Perez came out after Turner. Perez happened in 2010. And Perez specifically addressed Turner. It specifically addressed it in the body of the case. And Perez is almost on all fours with this case. It is a situation, well, it's 3 counts of lewd act on a child, and our case here is 3 counts of forcible rape, but those are the statutes that are governed by, or you can enhance what pursuant to Penal Code Section 667.61B, E, and 4. So in this situation, 3 different victims and that allegation under what is commonly referred to as the one strike law. They specifically addressed Turner. Turner is factually dissimilar in light of the fact that the 667.16 was not charged in Turner. Also, it was a robbery, not a sex crime. So factually, Perez is certainly more on point than Turner. They also stated that Turner should be narrowly construed to only apply to 3 strikes. 3 strikes, again, goes to recidivism. The 1 strike does not. And it looks just at the 1 charge with regard to it. And the penalty would be imposed based entirely on facts and elements proven in this individual case, not on prior convictions. So that also is something the court looked at. So I don't see that there is necessarily a split in authority, and I understand why you're saying it, because they're both determined to be alternate sentencing schemes. However, when looking at Perez compared to Turner, Perez seems to lay the groundwork what the court does, or gives me guidance what the court to do when a 667.61 is alleged. So with regard to that, because it is alleged, and you have the 3 victims, I believe there, Penal Code Section 799, subsection A, there is no statute of limitations. So therefore, your motion based on lack of jurisdiction because of beyond the statute, that is denied. Now, you also go in your moving papers, and I wanted just to quickly address it because it is in the moving papers. Initially, you said it's a due process violation on the 5th and 14th, but if you look at Penal Code Section 104 or 1004, that's not part of the grounds. I understand that's an umbrella that goes over a case, and in your moving papers, you argue somewhat of an ex post facto type of scenario, but I don't believe we have that here. Penal Code Section 266.61, that was enacted in 1994, so that was before the cases here. So it's not like the cases here happened and then that enhancement was added. So that argument doesn't fly. Then there's a motion to dismiss, and you cite Zamora and some other language that you use, at least in your initial demur, that lack of due diligence in the investigation, the witnesses have died, memories have faded, exculpatory evidence is lost, and therefore the defendant has been prejudiced. Then in your reply, you say, well, wait a minute, I'm not really making that argument yet. So there is no just kind of general due process argument. So I would deny it on that ground. But without prejudice, obviously, because you pointed out a lot has to be done in this case with regard to that. Then also you cite Penal Code Section 803F2. That applies when a child is involved. So that has no bearing because I think 3 or 4 lines before you make that argument, you note that the individuals in this case were adults. So that doesn't apply, and that's about requesting an evidentiary hearing. So then also you point out that Zamora grants the court discretion to do an evidentiary hearing. I respectfully deny or reject that argument. I just don't think in this particular case, based on how the court has just ruled, an evidentiary hearing is necessary. You'll have a chance certainly to have a preliminary hearing or whatever vehicle the people choose to do. And then if ultimately gets to trial, then that's when an evidentiary hearing certainly will be flushed out. So for all of those reasons, I'm going to deny the motion for demur. Also, I'll deny the request for evidentiary hearing. Then at the very end, you ask, for specific information from the people. I'm going to let you all work that out amongst yourselves. So I don't need to get involved in that. That's not in my wheelhouse. So I'll let y'all just work that amongst yourselves. I'm understanding why you're asking it because that might lead up to a further due process claim down the road. But that's not for here and now. All right. So the motion is denied. Where are we now?
Your Honor, I think Judge Espinosa is considering getting a time waiver from the parties so he can consider a possible all-purpose judge for the case. That's the last I heard.
The limited knowledge that I have on this is that if your client is willing to take a 90-day time waiver, that what I personally would do here, as opposed to you guys having to run between different courts, is that here, if your client waives time and we do a short set in 100 in whatever, in a week or so, do a short set and make that day 0 of 90, and then 100 will decide what court that goes to.
As long as we preserve our right under 170.6 to disqualify a judge if we choose,
Oh, of course.
we are willing to do the time waiver.
Right, because you haven't officially been assigned since 100 is just the vehicle to make the assignments. That is preserved.
Okay, yes, sir.
All right, so I don't even know. I guess your client has a right to be arraigned today. Does he wait and give up that right to be arraigned today? And what date do you want?
He does give up that right.
Okay. Or what date do you want it to go to?
Did you say 10 days? Is that what you...
Whatever's good for all of you. Why don't we take a just brief break? You all talk amongst
Sure.
yourselves. Pick a date, and we'll just make that 0, 90, and 100.
Okay,
And then we'll send you.
thank you.
So we're just research for that. On behalf of your client, does he understand he has the right to be arraigned today, go to preliminary hearing within 20 court days of today's date or within 60 days? And does he waive and give up that right and agree we'll put this matter in Department 100 on the 2nd of November as day 0 of 90 for arraignment and plea?
Yes, Your Honor.
All right, anything else I can do for you?
No, Your Honor, thank you very much.
Your Honor, because we have 977B in the file, our client does not have to appear on that day, is that correct?
Correct. Until the judge says he must appear, then I think you're good. Every judge is doing it different, but I don't see why we have to be doing that.
Thank you.
Thank you, Your Honor.
All right, thank you, everybody.
Thank you.
Good luck.
Thank you.